Hello friends, in the series on the income tax cases, today we will discuss a case where the assessee submits to prove that his land was agriculture land and the assessee is not liable to pay the tax under the head capital gain because rural agriculture land is not a capital asset, and the assessee submitted the government certificates issued to him to substantiate that his land is agriculture, but assessing officer, without verifying the veracity of those government certificates, directly rejected the claim of the assessee and made the additions. The issue before the court was that where the assessing officer is repeatedly doing the same mistake even after remanding the matter again and again. So what should be the recourse with the court in that case? This matter has been taken by Bombay High Court in the case of Ashok, Chaganlal, Thakkar versus National Faceless Assessment Center and others, and this case has been reported in 466 ITR at page number 726, and the matter has been decided by Bombay High Court, and the date of the judgment is 13th February 2024. In the present case, the assessee has sold some agriculture land, and when the assessment proceedings were going on, the assessee submitted two certificates, one issued by Talati and the second by Gram Sevak. When the assessment proceedings were going on, the assessing officer didn't verify whether these certificates are correct or not. The assessing officer did not make inquiry from the government departments whether they have been issued by them, and directly rejected those certificates without any reason, and does not bring on record anything contrary which prove that the land in question is not an agriculture land. When this matter travelled to the tribunal and then court, this matter was remanded back 3 times earlier by giving the direction to the assessing officer to verify the claim, but he was not verifying the claim and was again making the addition for one or the other reason. Even when the matter was before the CIT appeal and CIT appeal asked for the remand report from the assessing officer even did not responded to the remand report sought by the CIT appeal. So when this matter was before the Bombay High Court was inclined to impose some cost on the assessing officer, that why he is not doing his duty diligently. But the revenue again requested the matter to be remanded back to the AO with the further request that no cost should be imposed on the AO. And at last, no cost was imposed by the court and the matter was again remanded back to the AO. Friends, in these type of cases, there is a lot of harassment of the assessee, that when the assessee has done his duty and when the assessing officer has not done his duty, then why the assessee should be burdened with the cost of remanding back the matter to the AO, and why there should not be a mechanism that when the matter is at the appellate stages, then there should be a proper system that the verification should be done and the matter should not be remanded back because the assessing officer take the remand back in a very lighter way. The court said that when the revenue authorities are duty bound to verify the authenticity of such evidences, and if they want to reject the claim, they must bring the contrary material on record to disprove the claim. The court said that when the assessee has submitted the government records, the AO should have restricted his scope of inquiry that the land is situated in the municipality or the cantonment board or in an area which has a population of more than 10,000. AO should have done inquiry to ascertain the authenticity of the certificates issued by the Talati and Gram Sevak, which has not been done. So once again, the matter was remanded back to the AO. So friends, from this case, it is very apparent that there is no relief for the assessee and once their matter is stuck in scrutiny, they have to bear the cost of litigation and they have to spend a lot of time in the litigation. At the end of this video, once again I am repeating the name of the case. The name of the case is Ashok Chaganlal Thakkar versus National Faceless Assessment Center and others, and this case has been reported in 466 ITR at page number 726, and the matter has been decided by Honorable Bombay High Court, and the date of the judgment is 13th February 2024. Thank you, friends.